Well, good morning, everybody. It's Monday. I hope you had a great Easter and that the Easter bunny found you, or that if you're enjoying Passover, the Egyptians didn't. But here we are. It's spring in Washington. No trial today in the United States of America versus Joe Biggs et al. For whatever reasons, this particular courthouse takes the Monday after Easter off. So I'm sitting in my room trying to get ready to go home because I think I might be home by May. But silly me, who would have thought when I came down here in early January, we'd still be sitting here. Interesting development, though, in the case. The United States Court of Appeals for the District of Columbia issued a decision on Friday, the 7th, dealing with the issue of what corrupt intent means under one of the statutes that govern this case. And it created a lot of turbulence. Although we've worked out the jury charge, the court asked for supplemental briefing on the question over the weekend. You law nerds, take a look at it. It's United States versus Fisher. Three separate opinions by a three-judge panel. An opinion that was joined by one of the judges in concurrence, then a third judge dissenting. Seemingly little agreement about anything in the statute, but basically forecasting that this issue is almost certainly to be reviewed by the United States Supreme Court, and it's likely to do so in another case involving one of my clients, a case involving Edward Nicholas Lang, who was one of the parties in that appeal. We'll be discussing with him and his family later today whether to take an immediate petition to the U.S. Supreme Court. So never a dull moment, even on the Easter weekend. I'll spend the day today going over my trial notes, preparing closing arguments. You know, it's possible we'll give closing arguments this week, but realistically, they're likely to occur early next week. A lot depends on just how many defendants testify. In the case, there are 5 defendants. By every indication, 2 of them will testify, 3 will not. I'm not going to tell you which 2 and which 3. For that, you'd have to kill me, or at least attend the trial, which is killing me in an indirect sort of way. Mike, can you hear me today?
Yeah, loud and clear, Norm.
Yeah, last Friday, I didn't realize just how heavily dependent I am on Mike to kind of keep me grounded to reality and to move this podcast along. I had to go solo for a while, and it was frightening. We now have a new perimeter, a new border, or a new format here. I keep looking in the lower right-hand corner saying, who is that creepy guy with the orange aura around his head? And I'm like, oh, wait a minute. That was me years ago. So anyhow, welcome back, folks. Hey, if you're wondering, if you're trying to get a handle on just what's going on in the indictment of Donald Trump, I've got a treat for you. It's a short book. It's only 270 pages long. You can do it in a sitting or two, and it's called People versus Donald Trump. It's written by Mark Pomerantz, Pomerantz. People versus Donald Trump, an inside account. Pomerantz is a former federal prosecutor and a defense lawyer with decades experience in the criminal law. He was contacted late in the last term of Cyrus Vance to help give an opinion about what to do with Donald Trump. In other words, whether to indict him or not. And what's good about the book is if you're not a lawyer and you want to get a sense of how a criminal investigation takes place, what lawyers look for, what they do. This explains the nuts and bolts of the investigative process from the standpoint of a prosecutor, with insight from a defense lawyer on what he looks to defend a case. I couldn't put the book down, and I've been doing this stuff almost as long as Pomerantz could. And the reason I couldn't put it down is, I'm less interested in the politics of whether to prosecute Trump or not. I'm more interested in the mechanics of how this prosecution will work. And while Pomerantz was in the office with Vance, he was urging that Trump be prosecuted. He was urging that Trump be prosecuted because in Pomerantz's mind, there is no doubt that Trump is a serial liar. that he has falsified financial statements in order to obtain financing whenever possible. In other words, he overstates the value of his assets to make him look like a good guarantor, personal guarantor of financing. But he'll do that on a Monday, and then on Tuesday, he'll be bitching with local tax authorities that they've overvalued the properties that they seek to assess taxes on. He has a tendency within his financial empire of arriving at what he wants his net worth to be, and then instructing those who do his valuations to arrive at numbers that will support the net worth. It's
welcome to commercial real estate, Mark Pomerantz.
Well,
in the club.
And he says that it's interesting you should say that, Mike, because he says when they were kicking around what to do, some of the conservative wing, as it were, of the Manhattan District Attorney's Office were saying just that. If Donald Trump had an intent to defraud, or to engage in deceit in this basis, so does every other real estate developer.
Absolutely,
this is business.
1,000%, and it puts every local development board, zoning board under scrutiny as well. It puts the lenders and the financial institutions under scrutiny as well, because they have to do the underwriting if they're going to accept, someone at their word that the value of assets is X billion when it's really not. Everybody's got their hand in the till in that respect. And every property owner, every landowner is going to want that tax value to show as little as possible when it comes to their taxable income or their taxable value. And then they're going to want the reciprocal when it comes to being able to sell it. So that's the game.
Well, and Pomerantz acknowledges that, but then he says, if we're going to play that game, and everybody who apparently is involved in the system does, are we going to do it in a rule-bound way or not? And if we're going to do it in a rule-bound way, aren't there outer limits of what is and is not acceptable? It's not enough to say this is how thieves engage in thievery. We aspire towards something more, he argues. And the question then of whether to prosecute Trump, in his mind, didn't become a question so much of politics. In fact, he has said it wasn't political at all. But rather it became a question of respect for the rule of law. And if anything, he said, Donald Trump wasn't being contemplated for prosecution because of his partisanship. He was being considered for prosecution because he was at one point the highest officer in the land and asked us to place our trust in him. And if he behaved in an untrustworthy fashion, he brought this scrutiny on himself. But in any case, Cyrus Vance never did pull the trigger on a prosecution of Trump, and the office shifted from Cy Vance to Alvin Bragg. And Bragg was, because it's a heavily Democrat district, Manhattan, the primaries determined who the next district attorney was going to be. So Bragg won the primary in July. He won the general election in November and took office in January. And during that entire period, from June to January, never once made contact with the team that was investigating Trump. By the time the baton shifted, Bragg could never really be persuaded to pull the trigger on Trump. And as Pomerantz wrote his book, there was no prosecution of Donald Trump. And Pomerantz had his doubts as to whether it would ever occur. But he did prophetically say in the book that, the politically expedient thing to have done for Vance and maybe for Bragg would be to charge Trump in precisely the way he was charged. and this is the part of the book that makes it worth the read, I think, especially for those of you law nerds who aren't familiar with New York law, as I am not. The statute that Trump was charged with was falsifying business records, and it relates to the manner of recording the payments that were made to Stormy Daniels and others. And so, Michael Cohen, Trump's former lawyer, paid her when she surfaced in 2016 with a desire to do a tell-all about her affair with Trump a decade earlier. Cohen took a home equity loan of $130,000 and paid her, and then made an arrangement with Donald Trump to have Donald reimburse him and treat these on the books as though they were legal fees. And there were no, these were legal fees for non-existent work. And those records were falsified to cover that transaction. That is a misdemeanor in New York law. To make it a felony, they had to charge Trump with doing this with the intent to cover a violation of another law. And as a matter of New York law, that other law is not specified. In other words, is it a New York law or a federal law? And as Pomerantz points out, at the time the team was deciding whether to prosecute Trump, no appellate court decision in the state of New York had ever determined whether covering up a violation of New York by a federal law by altering papers in New York could constitute a felony in New York. And Pomerantz thought, it was worth the gamble to make that case. I think Pomerantz is right. Candidly, in the absence of any appellate authority, if I were writing on a clean slate and I had to evaluate whether Trump could be prosecuted in this manner as a felon in New York, I would say he could, because the crime is one of falsification of records with the intent to cover up the existence of some other unlawful conduct. Does it really matter whether that other lawful conduct that you're trying to cover up was itself a New York crime, a federal crime, or a crime in East Gitchagumi? And I don't think it does. The crime is falsification of documents that are kept pursuant to New York law. And if your reason for doing so, if your reason for doing so was simply that you were sloppy, or that you were modestly deceitful, well, I guess that's a misdemeanor. But if your reason for doing so was to cover up other misconduct, it seems to me that the crime itself is the alteration of records, and the more serious penalty goes to the more serious intent. That is to frustrate justice, not just in the manipulation of records, but for the purposes of keeping underlying criminal activities secret. Now, the counter argument would be, well, wait a minute, neither federal prosecutors in the United States district for the district of the Southern District of New York thought that they had a case for election violations or campaign finance violations, and neither did the FEC. That's a good argument. But the argument isn't that the statute doesn't read that you have to have sought to cover up evidence of another crime that necessarily you committed. It just means that you had to alter records to cover up evidence of another crime, whether charged or not. And so I think it's a fascinating discussion. I recommend Pomerantz.
Well, a little more there, just a little more there, Norm, because I think that just further on the counter argument side of things, we've talked about this in the context of a misdemeanor being elevated to a felony, or 34 felonies, right? So the underlying crime there is important, just the existence thereof. But we're also talking about a district attorney, and this is where we get more into the political side of things. But it's not insignificant, because it's objectively and observably true that the more liberal leaning, we can call it, Soros funded district attorneys such as Alvin Bragg have made a pattern all over the country of reducing felonious conduct into misdemeanors, or reducing what the charging guidelines are. So you have this unequal application of justice issue, at least from an optics perspective, that underlies this quite a bit. So, I can look at this, and I'm always skeptical of your literary diet when it comes to Trump, right? With the, you read the House Committee on J6's publication as well, right? You reviewed that. And then this in particular, what I've got here on the screen, Norm, is just the letter that was sent to Mark Pomerantz by none other than Joseph Tacopina. And this was earlier this year in advance of the publication of The People versus Donald Trump. And as Will has pointed out here in the chat, Mark Pomerantz went on quite a publicity tour to drum up sales for this book. And so it's to me, when you look in retrospect at what Bragg has done, it almost seems that he's come around because perhaps Pomerantz has primed the pump for him.
Well,
so
that's a great argument.
Taking as much of a political risk, right?
I think one of the things, I get that. And, one of the things that was striking to me is Pomerantz talked about how much hostility the decision not to get to charge Trump had drawn in like the comments section of the New York Times, and how many personal emails he'd gotten accusing him of being a hack for not prosecuting Trump, rather, suggesting that that nuttiness is a feature on the left as well as on the right. But a letter. I mean, if I got a letter in the mail from Joe Tacopino threatening me of something, I might giggle a little bit, because Joe is sort of like the froth on the third beer you had on a hot summer day. He goes a little bit to your head. But what is it? What is his claim? That Trump was defamed, and Joe Tacopino is going to sue Mark Pomerantz for defamation. I don't think Pomerantz is losing a lot of sleep over that. I read the book carefully. I don't think there was anything defamatory about it. Pomerantz shared the conclusions he reached after reviewing documents. And if Donald Trump seriously wants to claim that he doesn't lie in the creation of financial reports, then let him raise the claim and let's litigate it once and for all. But what I haven't read Tacopino's letter, so what does it say?
It effectively what you might think. So identifies who he represents in the form of Donald Trump, that he admonishes him to take seriously that this is an issue of defamation, and then makes the legal case for defamation, and also implicates Pomerantz's history as an attorney in so doing. He talks about how he would have come into knowledge of certain facts and circumstances that he would put in his book, and connects that to the ethical duty of someone in Pomerantz's former position, and then also talks about the way the book is marketed, such that he resigned, right, because they wouldn't bring this charge as a way to prop up book sales and that kind of thing. So I actually don't think the letter itself is totally off base. I'm always skeptical of letters that do their damnedest to put facts together with law as if this is some sort of brief for your legal writing class in law school. I always think that that's somewhat funny, because if there's a case to be made at all, it'll be made in court. And so these sorts of early stage letters are just somewhat comical to me in general. But
so here's
because I wanted. Go ahead.
If you publish the book and continue making defamatory statements against my clients, my office will aggressively pursue all legal remedies against you and your book publisher, Simon & Schuster. Yo, Joe, bring it. Let's get it on, pal. I mean, I would love, the subject of Donald Trump's net worth has always been has been a fascination of mine for as long as I've understood that Donald Trump had one. He once sued another publisher, Tim O'Brien, I think it was, if I'm remembering correctly, for a book he wrote in which Donald claimed that his net worth was that he claimed Donald overstated his net worth. Forbes has been all over Trump for years, trying to figure out just what his net worth is. I mean, according to well-regarded publications, Donald Trump even pretended to be the COO or CFO of his own organization, and adopted a false voice in the name of John Barron to try to persuade Forbes that he had a greater net worth than he had. So I don't think that there's a person alive who believes that Donald Trump is intimate with a concept most of us live with, aka truth. And so I would encourage the Donald to bring this defamation suit or through Tacopino's office.
There's a few things here I want to share. So T Girl in the chat says the House Judiciary Committee has subpoenaed Pomerantz. So that's interesting. And Lawyer Will has several good remarks here. Lawyer Will says, Google Mark Pomerantz's political contributions. He's made substantial contributions to Obama, Chuck Schumer, the Democrat Senate Campaign Committee. Pomerantz is a politically active individual who has made financial contributions exclusively to Democrats for 20 plus years. He has deeply held liberal beliefs, I almost said religious, Freudian slip. Wouldn't take anything that he says about his political enemies at face value. Google Mark Pomerantz political contributions. It's instructive, or just look it up on FEC.
Well, those are good points, Lawyer Will. I get it. But I guess I just call me a candy ass. But I no, I mean, and candy ass Pattis speaks again. I think when I go to court and appear in front of a judge, it never occurs to me who appointed the judge. When I'm litigating a case against an adversary under the rules of court, whether they be the rules of evidence or civil or criminal procedure, depending on the type of case. I don't depend on or don't care who my adversary is contributing to. I don't care about his or her motives, because the motives of an individual in coming to court don't matter. What they can prove does. And Pomerantz, in my view, has a proven track record as an effective prosecutor and an effective defense lawyer. Now, if he happens to believe that Hillary and company are a better choice for America because they better reflect his values, that's okay with me. That doesn't invalidate his work as an effective advocate. And I think one of the things I'm trying to do, and Mike and I are trying to do in Law and Legitimacy, is decouple quick appeals to partisanship from a set of objectively verifiable considerations that people of goodwill, but on different sides of the partisan aisle, can share. And so okay, Pomerantz is partisan, and there's no question in his book that he dislikes Trump, none at all. But his notions, his claims rather, that partisanship affected him not at all in his consideration against the case of Trump, strike me as a little naive and hard to take. But having said that, I still stand by my claim that for a good insider's view of how a prosecution gathers steam and takes shape from within the office of the district attorney in the city of Manhattan, it's a great book. It's a great book because it also talks about the tensions between state and federal law enforcement officers. It's a great book because it doesn't, it's not a scholarly treatise, it's not a law review article, but it does give a layperson a good working understanding of the statutes as applied in the investigation of Donald Trump. And it explains the prosecution that was actually brought.
Yeah. And look, Lawyer Will is responding to you in the chat in much the same way that I think I would, which I already kind of have here, which is, there are unprecedented facts about the indictment of Donald Trump.
True.
So he makes the observation that if you're before the Supreme Court of the United States, that political appointment is critical on some issues, which is obviously true. The trial level is not as important. But he also says, but when you charge the actual former president, which is unprecedented, political background becomes quite important, especially when the charge is thin gruel. And I think that there's no question that you and I have aligned on that, Norm, that of everything that has been thrown at Trump, this seems to be the thinnest of them all.
Oh, there no question about it. And you get the impression. You get the impression reading the book that oh, nice shot, Jacqueline P.
Everybody loves the candy. You self-identified as a candy ass. I'm gonna have to call you candy ass Norm from now on. The candy
ass man, the candy ass man, who can take a rainbow and call it blue and white. Okay, never mind. Look. There's no question that the prosecution is unprecedented. And reading Pomerantz's book, you get the notion that Bragg did it for partisan reasons. But here, and this is the kicker, according to Pomerantz, there was a much better case that Pomerantz could have brought, and he didn't. He chose the low-hanging fruit for expediency's sake. And I think this confirms Lawyer Will's point. If you're going to go after a former president, you should do so only on the gravest of grounds and for the most serious of offenses. And this might not have been the most serious offense. And I think that's right. I would have, and Pomerantz was urging the office to consider an enterprise charge, basically the state law equivalent of a RICO event, in that the Trump organization directed by Donald Trump is so steeped in fraud and misrepresentation that the enterprise itself is corrupt. And he cites none other than the recent conviction of the Trump organization and of Weisselman, his former accountant for tax evasion. And read the book. Read the book, Lawyer Will. It's quick. You can. I've had dinner with you. You're 5 times smarter than me. Lawyer Will. We sit down to read the menu. He glances at it. I'm still trying to pronounce the names of the food, and he's already got a great plate of Italian entrees ordered. So read a book. It's looking pretty good. I wrote a review.
Yeah, let's.
I wrote a review of it on Amazon too, so you'll take a look at the review. So, what platform do we prefer to watch from? I notice many more on Rumble. but ensuring what platform should I share? I have no frickin' idea, Jacqueline.
So we're live on 3 platforms every morning. One is Rumble Video. The other is Twitter Live, and a third is YouTube. Only one of those 3 have decided to strike any of our content from its platform, and that's YouTube. So I would say that between Rumble and Twitter, whichever fits your needs the most. Obviously, StreamYard, the platform that we use to simulcast each on each of those platforms, prefers the YouTube in terms of being able to put comments on the screen. I'm desperately begging Rumble to provide the same sort of back end via StreamYard. I have no idea what goes into that and why they haven't to date. But as soon as that happens, I don't know that we'll have very much use for YouTube, because I think we have less than 50 subscribers over on YouTube right now. 98% of our views come through Twitter and Rumble primarily. So, and I'll tell you this, Jackie, you're going to find way more people over on the Rumble side of things in the live chat.
Well, so there you have it. And, as in this business about YouTube and the strikes, I mean, it's infuriating. I guess we had 3 strikes in March, our first full month on YouTube. One was for inciting violence. And I'm like, seriously? You think we're inciting violence on this channel? You should be around when the microphones aren't on and hear what I have to say. This is calm and restrained by contrast to most of what I'm seeing in the course of a day. And 2 were for misinformation. They withdrew 1 without telling us what the third one that they sustained was. And we're pretty careful here not to truck, barter, and trade and rumor. We tell you who our sources are. We welcome engagement, and we take correction. So shame on you, YouTube. The algorithm has spoken. And we're aggrieved, and we can't even get a straight answer from the algorithm. And that's because, shifting to our next topic, algorithms are now telling us what is true. There's a good article in today's DailyKos. The wave of large language model AI isn't just a threat to a job, it's the end of objective facts. Is he right? And I think he might be. Take a look at the article. He talks about YouTube. Or not YouTube. He talks about AI, and I believe it's ChatGPT, making up citations for facts that don't exist. We talked about this last week with respect to Jonathan Turley and an article about him allegedly having sexually molested a student while a law professor on a university-led trip to Alaska. Newsflash: he never made the trip. And when ChatGPT cited an authority for this as the Washington Post, that was the beginning and the end for most people. So ChatGPT made up a fact and then made up which is almost forgivable, because it reminds me of what juries do. Jurors, we rely on the common sense of jurors and we tell them, use your common sense in drawing reasonable inferences from the facts, and then we will arrive at the truth. Well, that only applies for most cases, the cases that fall under the fat part of a bell-shaped curve. There are outlier cases. There are cases in things that are improbable are nonetheless true. But if you instruct a jury to draw inferences that are reasonable and to rely on those, and we rely on those reasonable inferences to arrive at the truth, the fact of the matter is we're expecting jurors to get it wrong some significant percentage of the time at the tails of the bell-shaped curve, and we accept that in the name of justice. It's not acceptable. With ChatGPT and AI, we now have large language models drawing inferences from data about what is reasonable. In other words, they will look for certain linguistic patterns or grammatical structures and then run through all of the known universe of reported utterances to arrive at probabilistic determinations of what the right answer is to a given question. Those answers may be right more often than not. They even may be right almost all the time, but they're going to be wrong a certain significant number of times. And if we place our trust blindly in AI because it's smarter than us, we don't know how it does its magic, but Hal has spoken, we're going to be relying on a fake sense of reality. And more to the point, and this is the sci-fi piece, what are we assuming that AI is aligned with us, is aligned with our interests? And are we assuming that it's a neutral actor? The fact is that someone has to create an algorithm. Somebody has to police the algorithm. Someone has to control the algorithm. And the person who creates, polices, and controls it is the person who ultimately has the power, not just over the distribution of goods and services that we rely upon, but candidly over our lives and over our sense of what's reality, what is real, and what is or isn't true. And so I think this notion of alternative facts. Remember when I think it was Kellyanne Conway or was it Sean Spicer? Both perhaps got savaged early in the Trump campaign for using that expression. It suddenly has teeth. And the alternative universe we're being summoned to live in is the universe that AI generates for us. And like lemmings, we could all be, led right over the edge of a cliff and not even know it, and go because AI tells us to go. So it's a serious issue.
Well, what struck me about the article that we have on the screen here is what I've actually put front and center, and the fact that now AI has been proven to have the capability to make up surveys and studies that never occurred. And in this case, we're talking about researchers who know what studies have been done and specifically what questions have not been asked in a controlled environment. And so they know that in this case, for example, do tweets increase citations to scientific articles?
Okay.
And ChatGPT says there is evidence to suggest that tweets can increase citations to scientific articles. Studies have shown that social media, specifically Twitter, can be an effective way to disseminate scientific research and increase its visibility among researchers and the general public. And then what happens is right there, it says in this case, the person asking the question happened to be an expert who had done research on exactly this area. He not only knew that the answer was incorrect, but he was able to use his contacts to establish that there was no such study ever commissioned.
No, and it's worse, Mike. You didn't read the sentence. It's most shocking. ChatGPT said a study by the American Association for the Advancement of Sciences found There was no study. And so that's more than just drawing an inference from facts and reaching a conclusion that might be reasonable. It's making shit up. And
imagine the casual civilian viewer who's clicking on an article that doesn't know the article has been published by artificial intelligence. And I think we talked about this last week, right? Where I told you that there was some transparency issues with the source of articles that we read day to day, right? Can we connect the article with a human person, or are we a society that is consuming more and more articles that have been arbitraged by AI? And if AI is referring to AI and AI is proven to manufacture things in a very specific bias or down a very specific pattern of what it knows to optimize for revenue, aka eyeballs and advertising, then we're going to get more and more and more of this.
Well, off we go into a brave new world. And, don't say that Aldous Huxley and George Orwell didn't warn you. And don't say that we're not trying to, too. So what do you do about it? I think you trust your eyes. You trust your community. You learn to speak to one another. And you rely upon your own intuition for arriving at a sense of what's true. And you wash your dishes when we're not broadcasting so that we don't hear the clattering of pots and pans in the background. So we've talked our way through another half an hour of your life. Thank you for having us. Mike will be back in civilization tomorrow, and our connectivity issues will be at least temporarily solved. I'll be back at it in the United States versus Joe Biggs. It'll be day 66 or so, but who's counting? We're having so much fun here. Thank you for listening. Mike, how do people find us?
You can find us every day on Apple Podcasts, Spotify, Google Play, Overcast, wherever podcasts are found. You can, of course, find us on Locals. That's lawandlegitimacy.locals.com. Consider becoming a member and subscribing. Rumble, obviously, that's where we talked about earlier. Rumble, Twitter, and YouTube. So find us there, subscribe, become a member. Maybe consider doing a subscriber badge. That would help a tremendous amount.
It would. We'll talk to you tomorrow. Thanks for listening, folks.